Well, good afternoon, all of you, either here in the room or online, or the ones who are going to be watching this on YouTube later. I'm Doug Jones, the chair of the Vancouver Island chapter of CARP, and welcome to this hybrid meeting at this wonderful Shoal Center, which we're collaborating with Beacon Community Services. So we wanted to just acknowledge the fact that this is the hybrid meeting of the CARP Vancouver Island chapter, and the next meeting will also be in this room at the same time. We are also acknowledging the fact that CARP Vancouver Island covers the entire of Vancouver Island plus the Canadian islands of the Gulf Sea. So, of course, we have throughout that land a number of First Nation, and we acknowledge the fact that this is their land, traditional territory in which we operate, and the people's whose historical and relationships to the land continue today. Just a little housekeeping, because of the fact that we're also recording, I want to remind you then that if those online would type into the chat function where they're from, it would be very helpful. And if you have questions, if you can bring up the questions in the chat, I'll monitor the chat function and we'll have that available for Dell as we go at the end. The other is that for those online, if you please mute your microphone, because I'm trying to broadcast the audio from the microphones of the people online. So when they ask a question, if they do it in person, you can hear them. So if they hold the questions both here and those online till the end, we can try to make sure everyone has an equal opportunity to ask questions. And if you keep them brief, Dale has promised me he'll keep his talk brief, so there's time for questions and answers at the end, and that will help get everybody a chance to ask questions. It is being recorded, as I mentioned. It will be available on YouTube about a week after the meeting, and I will send out a notice to our Facebook page to let you know it's available. And if you look at the Facebook page, it's very simple, just facebook.com/CARP Vancouver Island. So today's speaker is Dale Elgersma, who is well known to many people in this region. He's going to provide his perspectives on estate planning tips and tracks. I first met Dale online when we were trying to plan this session. And then he was recommended by our secretary, who, again, many of you know. Our secretary is Brenda Harfield at the front door there. And in our follow-up conversations, I was very impressed with the extent of his community involvement, as well as the fact that when I sat with him, I felt very comfortable. Not the kind of thing you see in the jokes about lawyers. It really did seem to be the most personable individual who you could talk to about issues and feel that he was listening to what I had to say, as well as had very good perspectives on that. And so that in his involvement with the area here very well matched what CARP tries to do in being the voice of seniors in this environment and also across Canada. So with that, I'd like to call on Dale to enlighten us and provide us some of his advice on moving forward. And for those who didn't get a pamphlet from here, you can contact Dell. He will get information to you, or if you're online, again, you can contact Dell and we'll get information to you as well. So with that, Dell, please.
Thank you so much, Doug. I'll try to speak loudly. I typically have a very loud voice, but I'll do my best, and hopefully you won't have to go to the YouTube channel next week to hear what I said. So I'm a lawyer with Beacon Law Center here in Sydney. I've been in Sydney practicing law for 29 years, came from Vancouver, love the islands, and Beacon Law Center is celebrating its 25th anniversary this spring. So and I've been doing estate planning since I was called to the bar in 1992. At the time, I was the youngest lawyer in BC. Certainly not that anymore. So we're going to talk about typical planning and some tips and tips to use and some traps to avoid for your estate plan. And I want to start by talking about incapacity planning, just planning for the possibility of incapacity. We're going to spend a lot of time today talking about the two certainties of life, death and taxes. But there's also the planning for the possibility of a disability. And so this planning hopefully never is necessary, never needs to come to fruition, but it's important to have these documents in place so that if you are incapacitated, you can be looked after. So typically, most people will need a power of attorney so that someone can manage their financial affairs, and a representation agreement so that someone can make their healthcare and personal care decisions. The power of attorney is, again, limited to financial matters, and in that document, you will appoint a person called an attorney. It doesn't mean a lawyer, it just means a financial agent who can manage your finances and your legal affairs on your behalf. So if you become incapacitated, your power of attorney can pay your bills, file your tax return, potentially sell your home if you have to move into care, or get a line of credit to pay for home care, those sorts of decisions. So very significant authority. It's very important to have someone that's absolutely trustworthy because they will be managing your bank accounts and your investments and all of your assets. And then the second part is a representation agreement for your personal care and your health care decisions. Now, if you don't have a representation agreement, by default, your spouse can make a decision, a medical decision for you. If you don't have a spouse, then an adult child. If you don't have an adult child, and by the way, any estranged family member is disqualified from this list. If you don't have children, then it's your parents. If they're gone, it's a sibling, otherwise a niece or nephew or your next closest relative. So if you don't have a representation agreement, family member or a close friend could make a decision for you. They would be appointed by the doctors if a decision was required, and they have 21 days of authority to make decisions about this particular healthcare matter, and then their authority ends, and any new healthcare decision would require a new appointment. So that doesn't sound very, very good. It's obviously best to have a representation agreement so that whole appointment procedure is not necessary. And it also ensures that the person that you would want to make these decisions is going to be the person making those decisions. Some people will also have other documents as part of their incapacity plan, personal directive or a living will, setting out the types of decisions that they want their representative to make for them, such as, don't keep me alive if I'm not going to recover from some intolerable disability. Pull the plug. That's a general example. If you have strong feelings about particular treatments, you might make an advance directive, which is a more formal personal directive. It has to be properly witnessed by two people. And actually, your doctors can follow that document directly. They don't even need to go to your representative if you've made an advance directive. If you're admitted to the hospital and they're going to perform a procedure, they might ask you to complete a MOST form, which stands for Medical Order for Scope of Treatment. And that form allows you to choose varying levels of intervention if things don't go the way that they hope they will go. So, are you just to be kept comfortable if things go sideways, or should they do everything possible to have you recover to your capacity? And finally, a DNR, do not resuscitate order, may be a part of your incapacity plan as well. But be careful, that means you're not to be resuscitated under any circumstances. So most people don't want that. They would say, no, if I could get CPR and I could get my heart going again, I'd be happy to have CPR. So a DNR means you're not to be resuscitated under any circumstances. So it's not for most people. With your power of attorney and your representation agreement, make sure that you name a backup so that if something happens to your first choice, if they're not around, there's someone that can step in. Make sure that Original documents are kept in a secure location, but probably not your safe deposit box. Because, for example, if your power of attorney is locked in your safe deposit box and you become incapacitated, the bank is going to limit access to the box to your power of attorney. But the proof is locked in the box. If you don't know where your original power of attorney is, go look for it. And if you can't find it or your previous law firm doesn't know where it is, then you need to go make a new one. Because if the time comes where it's needed, the banks and the land title office need the original document. And a copy will not suffice. So it's very important that the original exists and that you know where it is. If you're appointing more than one person, consider whether they should act together or whether they can act separately. If they have to act together, that's a little bit inflexible, especially if they don't both live in the same city that you live in. So it's more flexible if they can act separately. We often will recommend that, but with the proviso that they should consult with each other wherever possible. The Power of Attorney Act was updated 14 years ago, and powers of attorney are not allowed to charge a fee for acting as the attorney unless the document itself authorizes a fee and sets the rate of remuneration. So that's something to consider. Also, your power of attorney is going to be limited on continuing any charitable giving or family giving unless you authorize them to go beyond the statutory limits. So if the document is silent, your power of attorney can only donate or give up to $5,000 per year or 10% of your income, whatever is less. So that's the maximum of giving that can be done if your document is silent. So if you tithe to your church or you give generous presents to your grandchildren at Christmas time or on their birthdays or for weddings or graduations, you might want to override that limit and authorize larger gifts to be made during your lifetime. Your power of attorney and your representation agreement become void upon death, and that's when your will takes over. So a typical estate plan will consist of, for most people, a will, beneficiary designations, and perhaps co-ownership of some assets as joint tenants, or perhaps as tenants in common. The will deals with assets that you own in your own name. So your non-registered investment portfolio, if it's not owned jointly with a spouse or with your children, that's part of your estate and that will go through your will. If your car is owned in your own name, that goes through the will, your bank account. If you own shares in a company, that goes through the estate as well. Beneficiary designations are available to things like life insurance, your RIF or RRSP, and your tax-free savings account or TFSA. So with those types of investments, you're able to designate a beneficiary and the asset will pass outside of the will to the beneficiary that you've designated with your financial advisor. And if you own your home with your spouse as joint tenants, when the first spouse dies, the home will pass to the surviving spouse by right of survivorship. It doesn't go through the will. It passes on because of the joint ownership. Now, if you own your home with your spouse as tenants in common, that's a different story. Then your share of the home will go through your estate and pass through the will. So in addition to those three methods of inheritance, there's also the ability to create a trust while you're living. We'll talk a little bit more about this later on today. Or you can die without a will, and then your assets are passed on through a government formula, and that's called an intestacy. And that formula basically says that your estate will be divided between your spouse and your children. If you don't have a spouse or children, then it goes to your closest relatives, your parents or their descendants, or your grandparents or their descendants. And if you don't have relatives within those relationships, then it goes to the provincial government. So for the rest of this presentation, I'm going to be focusing on tips to minimize probate costs, reduce income taxes, and avoid estate disputes. So let's start with probate. What is it, and when and why is it necessary? Well, let's assume that you've passed away, then your executor goes to the bank and says, here is the death certificate proving that the person has died, and here's the will proving that I'm the executor. Well, the bank would say, the death certificate we can rely on because that's a government document, but we can't rely on this will. We don't know if the deceased made a later will. They might have made a later will appointing a different executor, might even have different beneficiaries. And if we rely on this will, and we give you all the money, and then someone comes forward next week and says, actually, here's the later will, the bank would be in trouble. So they will not release the funds to the executor until the will is probated. So the executor has to make a court application. Now, I'm talking about sole assets, by the way, not joint accounts. Joint accounts pass to the surviving owner, but if you had a sole account in your name, that's what the bank would say. So the executor has to go to court, make an application. They just file various documents. And one of the affidavits that they will have to swear with a lawyer or a notary is that they have looked everywhere for your will, including on your computer, because electronic wills are now valid in BC. And they believe that the will that they have is the final will. So they submit that affidavit and the original will to the court. They also submit an affidavit listing all of the assets in the estate. So that does not include assets that were jointly owned that passed to the surviving owner. It doesn't include your registered accounts if those had designated beneficiaries, but all of the estate assets get disclosed. And then the court will review the paperwork. Also, as part of that application, the executor has to actually send a copy of the will to all of the beneficiaries and to anyone that would have inherited your estate if you died without a will. And then has to wait 21 days and then can make the application. So if no one has filed any objections, the court will review the paperwork and calculate the probate fee, which is 1.4% basically of the estate value. It's a little bit less on the portion of the estate under $50,000, but on the value over $50,000, it's 1.4%. And then they will, once that fee has been paid, they will issue the grant of probate, which is a court order authorizing third parties like the bank, ICBC, the Land Title Office, to recognize the will. So that's what probate is, and that's why it's required. Now, if you passed away and the only asset that you had was shares in a private company, because you were a business owner, you sold the business, all the money went into your company, and you're living off the company's investments. You don't own a home, you don't own a car. Probate is not going to be required because the only asset are your company shares, and the articles of private BC companies allow those shares to pass to the executor without probate. It's at the discretion of the executor who becomes the director of your company and is then able to liquidate the company and divide the assets among the beneficiaries. But I'm just showing that there's no mandatory requirement for a will to be probated. Similarly, if the only asset is a valuable art collection, it could be worth millions of dollars, but there's no registry for art. The executor doesn't have to go to a registry and prove that they're the executor. They can just contact Sotheby's or Christie's and make arrangements to sell the art without necessarily probating the will. Now, probate has a bit of a bad rap, but it actually has a few advantages. One is that there's probably increased oversight and accountability because it is a court process, and a judge is going to be reviewing the documents that are filed by the executor. And so there's that oversight and accountability. Also, the requirement for the executor to send the will to the beneficiaries and to those that would have inherited if there was no will, results in increased accountability. There's also, under the Wills, Estates, and Succession Act, the executor is not allowed to distribute the estate until 7 months have passed from the date of the grant of probate, unless all of the beneficiaries agree to an early distribution. So if you have a beneficiary who's difficult, they might refuse to give consent. And it might be necessary for the executor to get a grant of probate simply to start the clock on that 7-month hold period. Because once the 7-month hold period is over, then the executor can go ahead and make the distribution without beneficiary approval. Now, the disadvantages of probate are that it does take some time. As I said, the will has to be sent to various people, and then the application can't be submitted for 21 days. And as part of the application, the executor has to list the date of death value of all of the assets in the estate. And it can take some time for the executor to get that information from your bank. They have to provide the exact date of death value in your accounts. And sometimes they'll send the executor's inquiry to the estate department in Toronto, and there won't be an answer for 2 or 3 months. So that can delay the whole process. But otherwise, once the application is filed, typically the grant of probate is issued within 2 to 3 months. And then, as I said, there's that 7-month hold period unless all of the beneficiaries agree to waive that hold period. Now, probate gets a bad rap for causing a delay in the estate distribution, but I would argue that sometimes the Income Tax Act should take more of the blame. Because if, for example, you pass away in January, your executor is not going to be able to file your final tax return until the next spring. So they're not able to file your final return for over a year. That is going to potentially delay the estate distribution. Now, if the accountants are comfortable with what's been happening, they could suggest a holdback that the executor could keep in reserve, and then the executor could make an interim distribution in the meantime. Now, the other disadvantage, of course, of probate is that typically it requires the assistance of a lawyer, and that costs money, and the payment of that 1.4% probate fee. So there are some tips on how to avoid probate that I'd like to share with you. The first is that make sure that you've designated beneficiaries whenever possible. So if you have a RIF or a TFSA or a life insurance policy, appoint a beneficiary. Typically, it would be your spouse if you're married, unless maybe not if it's a blended family. That's a different scenario. But then also consider appointing contingent beneficiaries, so that if you and your spouse died together, rather than those funds going into the estate, they would be paid directly to your children or your contingent beneficiaries, whoever those are. And that would keep those funds from having to pass through the estate and then being subject to probate fees. If you have shares of significant value in your, you own a private company, or if you have a valuable art collection, consider making dual wills, where you would have a separate will for those assets, for the art collection or for your company shares. That will, as long as it has a different executor from your general will, does not have to go through probate. Okay? As long as your beneficiaries are reasonable and would consent to a distribution of the assets under that will without a grant of probate. So that can be a significant savings in probate fees. You could also put all of your assets into an alter ego trust, or if you're married, a joint spousal trust. So this is the trust that was created under amendments to the Income Tax Act, I believe in 2001, where if you're over 65 years old, you're allowed to transfer assets into this trust without triggering any capital gains taxes. Normally, if you put assets that you own into a trust, you're deemed to have sold the asset and you'd have to pay capital gains tax. But with these trusts, you're allowed to roll them into the trust tax-free, and the tax is deferred until you're dead. And any income earned in this trust is taxed as if it was earned by you personally. So they're a nice type of trust if you're over 65. And because it's a trust, not a will, there's no probate. Now, if you have, let's say, real estate that you want to put into this trust, the property transfer tax might be more than the savings and probate fees. So it doesn't always make sense, but it's something to consider. And finally, if you're a married couple, you might want to consider setting up your estate so that probate is not required when the first spouse dies. Again, if you're a blended family, this may not be appropriate, but if you're not a blended family, try to hold all of your assets jointly, or make sure that your spouse is the designated beneficiary of your RIF and your TFSA. And when the first spouse dies, there may not be any estate at all, because all of the assets have passed outside the estate. And so no need for probate until the death of the second spouse. Now, some traps to avoid. Vehicles. Often my clients will say, oh yeah, we own everything jointly, and they'll ask about the vehicles. And oh yeah, you're right. I bought that vehicle on my own because you weren't around, and it's just in my name. And ICBC's policy is that if your estate, when you die, is under $30,000 in value, they will allow the car to transfer without a grant of probate. But if the car is worth more than $30,000, then probate is going to be required simply because the car wasn't in joint use. Or if you have a $20,000 car and a $20,000 bank account, you're over the threshold and probate would be required. Another trap is joint tenancy with children. Now, this is something that's done fairly commonly these days as a way to avoid probate, but there's all sorts of issues with it. And one of the issues is that if your child was sued, the creditor, if they got a judgment against your child, could register that judgment against your house if you put the house into joint names with your kids. If your child dies before you, then their interest just goes right back to you, so the planning won't have worked. Or let's say that you put the house into joint names with both of your children, and one of your kids dies with you or before you, then the house is going to go entirely to the one surviving child, and nothing will go to the family of the deceased child, and that may not be what you intended. So that's an unintended consequence. There's also a loss of control, because if you want to sell your home or get a line of credit, which requires a mortgage to be registered on the title, you won't be able to do that without your children signing the paperwork. Now, typically, we would have them sign a contract where they agree to sign whatever paperwork you ask them to sign, but they could break the agreement, simply refuse to sign, and then you're not able to sell or mortgage the property, and that's happened before. Also, depending on how you set up the joint tenancy, you might be triggering taxes. And you might have a capital gain tax bill to pay in the spring after you've done the transfer. Or if it's your principal residence, perhaps the child's share of the increase in value is no longer tax-free because it's not their principal residence. So there's ways around those problems, but it does require that you get proper advice. The other issue that's come up in the last few years is that Canada Revenue Agency was going to require that if your children were on the title of an asset or of an investment portfolio, just for the purpose of avoiding probate, that it was still, the asset was still considered yours while you were living, that creates a bare trust where your children are considered to be trustees holding the asset on your behalf. And the Income Tax Act required that your children would have to file a tax return for that trust. And those first returns were due on March 31 of last year. And I think on March 29, the government said, okay, we're actually going to delay this after, thousands of Canadians spent thousands of dollars on these tax returns. They delayed it. They haven't called it off. So if we're not sure exactly what's going to be happening, but it's possible that if your children are added to the title of your home or to your portfolio, they might have to file this tax return. So adding them to your assets to avoid probate is not everything that it's sometimes promised to be. So let's switch over to income taxes. Canada actually does not have an estate tax. We used to, but it was removed when capital gains taxes were brought in the early 70s. So instead, the moment before your death, you're deemed to have sold all of your assets. And that results in capital gains taxes becoming payable. And if you have a RIF or an RSP, whatever balance is in the RIF at the time of your death is considered to be income that you earned in your final year of life. If you're on your death, the assets that are not going to be taxed are your principal residence, other than any appreciation that may have occurred while it was not your principal residence. So some people have a home and they didn't move into it right away. They rented it out for a few years and then they moved in. Upon your death, the capital gain is going to be limited to the appreciation that occurred while it was a rental property. But any appreciation that occurred while it was your principal residence will be exempt from tax. Life insurance proceeds are tax-free. Proceeds of your TFSA are tax-free. And GICs, term deposits, cash are tax-free because they don't have any capital gain. A dollar is a dollar. What is taxable are the capital gains on all of your other assets. So rental properties, your non-registered portfolio, company shares, a recreational property, and your RSP or RIF proceeds are considered income earned in your final year of life. Yeah. So let's consider that you have a RIF of $500,000 and you pass away. You will be deemed to have earned $500,000 of income in your final year of life. And that income has to be reported on your tax return. You're going to be considered a very wealthy Canadian in the highest tax bracket. And you can consider at least 40% of the RIF to go to the government in taxes. So let's talk about what we can do about this tax problem. Well, one thing is to use a spousal rollover. Whenever you leave taxable assets to a spouse, the tax is not payable until your spouse dies or sells the asset. So if you're in a blended family and you want to provide for your spouse, but also for your children of the previous marriage, try to arrange it so that the RIF will go to your spouse, because then it's not taxed. It can be added to your spouse's RIF. I mean, your spouse will pay the tax as they draw it down, but there won't be that big tax hit that I just mentioned. And try to give your other assets, like your TFSA, to your children. You can also leave assets to your spouse through your will, and it can be left as an outright gift or through a spousal trust, where the spouse is given the use of the asset during your spouse's lifetime. They would have to be entitled to all of the income from the asset, and no one else can have the benefit of the capital until your spouse passes away. In that type of trust, any assets left in a trust like that are the taxes deferred until your spouse dies. Also, your executor can consider taking advantage of the fact that for the first 3 years after your death, your estate will be considered a graduated rate estate. That means that your estate will pay tax on its own income at its own graduated rates. So if you pass away and you have $1 million of assets in your estate, rather than distributing that money right away to the beneficiaries, and now they're paying tax on that, on the income from that money, consider keeping that money in the estate for up to 3 years and letting the estate pay tax at its own graduated rates, which may be lower than the income tax rates that your beneficiaries are paying tax. Now, if you're really wealthy, and if your children are really wealthy, you might consider setting up a testamentary trust for your child and your child's family. So let's say that you have, your child is going to receive $1 million. If they've already paid off their mortgage and are doing well financially, they will likely invest the inheritance and they will have to pay tax on all of the investment income because it was left to them. They can't shift the tax burden to their spouse or to their kids. But if you leave that $1 million in a trust for your family, for your child and their family, your child can direct that the income be allocated to any member of the child's family. Your child's spouse, your child's children, even grandchildren. If your child has children of their own, your grandkids, they can allocate the income to go to the grandkids to pay for the grandkids' university tuition. And Canadians can earn up to, I think, $40,000 a year and not pay any tax. So this type of a trust can save a lot of money for your child and their family. But it's obviously not for everyone. And finally, charitable giving gives some really great opportunity to reduce your taxes as well. So in your last year on your death, you're allowed to make charitable gifts of up to 100% of your net income, and to get a refund of the tax paid in the previous year before you die. So it's the income tax is very generous. It really promotes charitable giving upon death. So a couple of ways of doing this: you could appoint charity as the beneficiary of your RIF, and that would completely eliminate the tax on the RIF, and then leave the rest of your estate to your family. Or you can put in your will what we call a tax eliminator clause, which is a clause that says, I want my executor to calculate the size of donation that would be required to reduce my taxes to zero and to give me a refund of the tax paid in the year before I die, and then make that donation to my favorite charities that I've named here. And you can put, no less than X dollars and no more than Y dollars. So if you want to make sure that it's at least a $20,000 gift, you can put that as a minimum. If you want to make sure that the gift doesn't exceed $100,000 or $200,000, you can put that as the maximum. So it's very flexible, and it ensures that the charities are only going to get the amount needed to reduce your taxes to zero, and the rest of your estate will go to your family. And finally, if there's a charitable donation in your will, the executor can give the charity publicly traded shares that are in your non-registered portfolio as a way of paying that gift. So if, for example, you leave $50,000 to the hospital foundation, the executor could sell your portfolio, pay the capital gains tax, and then get a donation for the $50,000. But the better option is for the executor to actually give $50,000 of shares to the hospital foundation, and then the estate doesn't have to pay the capital gains tax, and still get the charitable donation receipt for the $50,000. Now we're going to talk about estate disputes and some tips to keep those to a minimum. Unfortunately, there's a lot of opportunity for estate disputes, especially in British Columbia, where we have a very unique law. It used to be called the Wills Variation Act. Now it's part of the Wills, Estates, and Succession Act. And it provides that if a child or a spouse is not adequately provided for in a will, they can apply to the court to have the will varied. So if you disinherit a child, there's a very good chance that they could have the will varied so that they're put back in the will. Or if you're a blended family and you've left everything to your spouse, your children would probably have a very good claim to challenge the will. Or if you left everything to your children and nothing to your spouse, then your spouse could have a good claim against the will. There's also disputes around joint tenancy, disputes over whether the person had capacity, and there can be disputes over the interpretation of documents. Especially because BC now recognizes or has the ability to recognize holograph wills and other notes that aren't a formal will. So in the past, until 2014, holograph wills were not legal in BC, and the only document that could be treated as a will was a document that was signed by the will maker and witnessed by two people in a particular way. But now, if you leave a note, the executor or an interested party can go to court and say, we think that this note reflects the deceased person's intentions, and we would like you, court, to treat this as if it's a will. And these notes can be a little bit ambiguous. So there's lots of room for interpretation disputes now. Now, wills variation claims, as I said, are a special risk for blended families. Some of the ways of avoiding these claims are have a marriage agreement. So we would call that maybe a post-nuptial agreement, where you and your spouse agree on how you're going to divide your estates, and you agree that you're not going to challenge each other's will. Now, if things turn out to be unfair, then the surviving spouse, could still go to court and say, I don't think my spouse's will is fair and I think it should be changed. But the court's going to give a lot of weight to the fact that you had this marriage agreement in place. A child or any claimant cannot challenge a beneficiary designation. So if you leave your RIF or TFSA to a beneficiary, that can't be varied. And if a lot of your wealth is in non-registered funds and you're worried about a claim, consider putting those funds into a segregated fund where you're allowed to designate a beneficiary. And then the funds can pass to the designated beneficiary rather than through your will. You can also consider putting assets into joint tenancy. So if you have two kids and you want to make sure that your house goes to just one of them, consider adding that child to the title of the house. Just make sure that you're doing it properly with the right advice. And then on your death, the house will pass through the joint ownership to that particular child, and the child who's left out, they won't have a claim because it wasn't left through the will. You can also set up one of those trusts that we talked about, an alter ego or a joint spousal trust. And because those are not wills, they are not subject to that same law. So blended families have some special considerations as well. Again, a marriage agreement can be useful for a blended family. And then as far as how to divide your estate, there's probably three main options. One is to do a division of assets between your spouse and the children from your previous relationship. And you just have to figure out, what is a fair division. Another option is to leave everything in a spousal trust. So leave your assets in a trust for your spouse. The spouse gets all of the income and the use of the assets during their lifetime. But when your spouse dies, then those assets go to your children. Or consider putting everything into joint ownership with your spouse so that the assets go automatically to your spouse and can't be challenged by your children, but then enter into a mutual wills agreement, which is a contract between you and your spouse that when the last of you dies, your will is going to provide for both sides of the family. Now, those agreements aren't ironclad, but sometimes they're the best that you can do. A lot of estate disputes arise because there's poor communication, or simply you appointed the wrong person as the executor or as your power of attorney. So a couple of tips, as I said earlier, always have a backup. Make sure that you appoint someone with the right characteristics for the job. They should be responsible and prudent, patient and calm, able to manage their emotions, not too busy. They should be willing to get professional advice when needed. So someone that's a know-it-all or overly frugal is not really a great executor, because they might try to do it on their own and get themselves into trouble. Communication is critical, and they should be there when needed. Try to avoid appointing someone who procrastinates, who's not good with paperwork, who doesn't have financial experience, might be in a conflict of interest. So if you have a business, for example, don't appoint your business partner, because their interest will be different from that of your family. Don't appoint someone who's overly sensitive, because they're bound to get some criticism as they carry out their role. If someone has a pattern of dysfunctional relationships, that pattern will probably continue through acting as your attorney or your executor. Someone who is depressed or anxious is not a good choice. I know of estates that have taken years to administer because the executor was depressed or had anxiety, and they just couldn't face it. And so the estate just sat for years. Tips to avoid other estate disputes. Deal with gifts or loans that you've made during your lifetime. Deal with those explicitly. So if you made advances or gifts to your children during your lifetime, consider a clause in the will that says that you want those gifts to be equalized when you die, so that everyone, at the end of the day, will have the same benefit. Or, conversely, put a clause in that those gifts stand as they are and there's no equalization, or a clause that forgives any loans that you may have made to your children, or confirms that the loans are to be collected. I have dealing with an estate right now where mom passed away and she had 2 children. She had made a loan to her son of $100,000 and told him verbally that it was forgiven, but didn't tell her daughter. And now mom's passed, and the son and daughter arguing about whether that loan needs to be repaid. He says, no, mom forgave it. And she's saying, well, show me the proof. So they're still working that out. If you create a joint tenancy with your children, whether it's an investment account or with your house, make sure that your intention is well documented. There are lots of estate disputes these days over these types of joint ownership arrangements. When you pass, the child that was added to the account might say, well, mom wanted me to have this account because I was giving her so much help while she was alive. So this money is now mine. And the other kids might say, no, mom put that account into your joint names simply to avoid probate. And you're supposed to share it with all of us. So lots of disputes over that. So make sure that your intention is documented, and then there won't be a dispute. Is it intended for that one child, or is it meant to be shared with everybody? Make sure that your documents are kept in a secure location. I think it happens more often than we know about, where someone finds the original will in a filing cabinet in your home, doesn't like who was appointed as the executor, or doesn't like the division, and suddenly there was no will. Nobody can explain what happened to him. So keep it secured. I would recommend that you keep it with your lawyer, and that they file a wills notice with Vital Statistics, who maintains a wills registry. Try to avoid do-it-yourself planning, and use a legal specialist, especially if you're going to be doing joint tenancy planning or creating a will. for one thing, your intentions will be documented, so there's less chance of a dispute. And also, the legal specialist will be able to give evidence and confirm that you had capacity, you knew what you were doing. And so there's less likelihood of someone challenging the document on the basis that you lacked capacity. A couple of do-it-yourself stories I can share. There was a mother who wanted to treat her children equally. She had a $500,000 RIF and a $500,000 condo. And her daughter actually lived with her in the condo. So she created a will and said, I leave the condo to my daughter because I'm leaving my RIF to my son. So when she died, the son got $500,000 from the RIF, and the daughter got a tax bill for $200,000 and had to sell the condo to pay the taxes. So the mom just didn't realize that that's what would happen. And that's what can happen when you don't get the right advice. Often people that write their own wills talk in percentages. So I give 25% to this person, 25% to that person, 50% to this person. Well, what happens if that person dies before you? If it was the 25% beneficiary that died before you, now only 75% is being distributed through the will. What happens to the 25% of the deceased person? Basically, that 25% has to be distributed through the intestacy laws. Whereas if the will said, leave 1 share to this person, 1 share to this person, and 2 shares to that person, then if the one person died, there'd be 3 shares instead of 4 shares, and we wouldn't have that problem. So just a small example. And with that, I think I'm open to questions.
Okay, thank you. All right. So we'll take the first question from the audience here while I set up the chat at the back there. Yes, go ahead.
Yeah, so the question was asking about electronic wills now being valid in BC. So electronic wills are now valid, but what that means is that you've signed your will in the electronic presence of 2 witnesses. So it basically requires a Zoom call with 2 witnesses, and they will literally watch you on the screen as you sign your will. And then you have to watch them as they witness the will. And you'll sign it either in counterparts, so each of you will sign a paper copy, and then those copies get combined into one document. Or you can do an electronic DocuSign or Adobe Sign, where you take turns signing electronically, but you have to watch each other on the screen. So that's how it works. So it's a little bit complicated in order to be valid. Yeah. Yes. Yeah, your Alberta will is going to be valid here. Your Alberta power of attorney will be valid here, but if it's needed for land title purposes, the land title office will require a legal opinion from an Alberta lawyer to say that this power of attorney in Alberta is valid for Alberta real estate purposes and therefore should be valid for BC purposes. So sometimes it's just better to make a new BC power of attorney, but your will should be fine. Yes.
Thanks again for the presentation. I was wondering if your beneficiaries in your will reside in a different country. So yeah. So you need 2 wills, one for BC, one for the other country.
Yeah, so if you have beneficiaries outside of BC or outside of Canada, you do not need a separate will for them. If you have assets outside of BC or outside of Canada, you might want to consider separate wills, depending on the situation. You'll need advice, but your beneficiary might want to get advice about how their inheritance will be dealt with in their jurisdiction. But in most jurisdictions, inheritances are usually tax-free.
Thank you. Talk a little bit how you for a child that's on a disability.
Yes. Yeah. So if you have a child who is disabled, if they're receiving provincial disability benefits and they receive an inheritance outright, their benefits will be cut off because they'll no longer be eligible. So it's important to create a trust in your will so that their benefits are preserved. And the BC government is actually very generous as far as these trusts go. They can be used to fund vacations. The trust can be used to buy a home for the person, to buy a car, and to pay for caregiving and so on. So would be really advisable to make sure that there's a trust for that disabled beneficiary.
Is there a certain type of trust or?
We call it a Henson Trust, but it's typically a discretionary disability trust. And discretionary means that the payments are at the executor's or the trustee's discretion. If the trust was under, I think, $200,000, it doesn't have to be discretionary. The beneficiary can have some say in how the money gets spent. But if it's over $200,000, the beneficiary can direct the payments, then they can lose their benefits. Question, yeah.
About the corporate trustee
Yeah, so
as opposed to these relations.
yeah, so your trustee can be a family member, a friend, a lawyer, an accountant, or a trust company. And most of the major financial institutions and a lot of financial investment firms either have or are affiliated with trust companies. And they'll be happy, as long as your estate is worth a certain minimum value, they are happy to administer a will, and in some cases, even to act as a power of attorney.
We have two sons. One son we helped a number of years ago with some funds for a condo, about $60,000. We told his brother, and his brother, the character that he is, said, "Oh, that's fine, Dad. Don't worry about it. We'll sort it out ourselves." There are danger flags there, I think. I would think that you might advise that we make this legal. I don't know how we do that. I thought we changed the will. Add it to a will.
Yeah,
Can you advise that?
It really depends on the circumstances. So the question was, two sons, one was given $60,000 for a down payment. If that son is in more financial need than the other son, you could leave it. But if you want things to be equalized, then you could consider what's called a hodgepodge clause, where hodgepodge is an archaic English word that we still like to use as lawyers. And basically says, when my executor divides the estate between the two sons, they have to take into account that the one son already got $60,000. And so the other son then gets $60,000 extra from the estate.
I'm sorry, where do we go in the
That goes into the will.
Yeah.
Yeah. And the other possibility is that if it was a loan that you made to your son, just have him sign a promissory note, and then you don't need to update your will. The note is considered an asset of the estate and gets set off against the child's inheritance.
We have a question in the front down here.
Oh, okay.
Go ahead.
Yeah.
If you leave all your assets to a charity, is there then no tax paid?
Yes, if you left everything, you were the last spouse to die and you left all of your estate to a charity, assuming that your RIF also went to charity, there would definitely be no tax payable. It won't.
Okay. One last question. Go ahead.
Pardon me?
Is that third list of
You can, but it can complicate the estate. And thank you for asking that question. I meant to address that. If your power of attorney is a US person, there are some investment firms in Canada that are not licensed to deal with US powers of attorney. And they simply your US person will not be able to manage your investment account. So that's a problem. If your sole executor lives outside of Canada, then your estate will likely be considered a foreign trust and have extra, there might be more tax to pay or more tax filings that are required. So it's not recommended. But if you have two executors, one of them is in Canada, one is outside of Canada, given that you were in Canada, your assets are in Canada, that should be okay.
Yes. Well, maybe I'll let you ask the one last question.
So your executor lives in Edmonton, but you live here. It's not the most convenient situation for your executor, but if they're able to take some time off to come here and empty your condo or make arrangements for that to happen, it should be okay.
Okay. Let's call it there so we stay on time. So thanks very much.
So in closing this meeting, I just want to thank Dale very much. Because I think there's a lot of good information that came out, and I think it's obviously important to think of aspects when some of us try to do DIY, end up DIY in the ditch, which is probably not the way to go. So thank you very much as well for all that advice. And of course, Dale's quite willing to answer some questions, and you can get a hold of him as a lawyer. If he is one, so that would work for some of you as well. Also, thank you to Jennifer Van Eck, Director of the Shoal Center and the Senior Services, and the staff for helping set up the meeting for today. A great place for us to meet, and also to the board who's helped with the registrations coming in and keeping us all going here at the CARP. The session has been recorded. As I mentioned to you, it'll be available on YouTube in about a week. Mark your calendars for our next meeting, which will be here, this room, May the 14th, same time. Our guest speaker will be Rolly Beck. He's at the door, came in, retired, with years of management and recently speaking on wellness and retirement. And his talk will be 4 pillars for an enjoyable retirement. We hope to see you at the meeting, and information will always be in our newsletters and also on our Facebook page. We go forward. And we would like to hear from you. Send us an email. Email is just Vancouver Island at carp.ca. So that may help as well. And for all the rest, I hope you've enjoyed this session. Enjoy the rest of your afternoon. Thank you very much for coming.